told you, this hour, we want to dedicate it to a hearing going on for Bryan Kohberger. My understanding is if we can get a shot of that courtroom, the judge is now on the bench out there. And so we're going to take you out there live as soon as they get going. Here's what I want to do. Let me bring in my guest. Joining me right now is Darnell Crossland. Darnell, you know, are you with me?
Yep, I'm with you.
All right, Darnell, let me ask you a quick question about what's coming up today with Bryan Kohberger. Very interesting issue going on there with Bryan Kohberger. It involves the defense hiring or commissioning a company to ask questions of potential jurors in support of their motion to change venue. Now, generally, you see these things, and they're not uncommon. They happen from time to time, and it's just good lawyering, as was argued by Bryan Kohberger's attorneys. But the problem here is some of the questions involve information that was taken from the media about the case. This was not provided by the defense, at least according to their arguments. It was information taken from the media, and there's a gag order in the case. The judge didn't want anybody to put any information out there that could potentially prejudice jurors. So the state says, you know what, we can't let them do this. I want to get your thoughts on just the overall issue in this hearing.
Well, when it comes to change of venue, obviously, what you're looking to have is a neutral a jury, impartial jury, a jury that hasn't made up their mind. When you have high-profile cases, you have to balance the First Amendment right to free press, a transparent and open court to the public, and that of the issue of whether the jury might be unfairly prejudiced by the coverage, depending on where the coverage leans. You don't want a jury to start a case with their minds already made up. With that being said, if the defense feels that the media coverage has been so overwhelming and it's been determined by either a poll or some type of other external information that the jury may be prejudiced and their client won't have a fair trial, then I think it's fair grounds for the defense to make a motion to change the venue to a place where there'd been less coverage and less of a chance that a jury in that new location would have already made up their mind before starting to hear the evidence.
All right, sounds good. Darnell, stand by, because my understanding is things have gotten underway in that courtroom. Let's take you out there live.
The state, can you hear me okay?
Yes.
Yeah, okay. I think we have Mr. Nye and Ms. Beatty on Zoom. Anybody else on Zoom? Ms. Taylor?
No, Mr. Logsdon is not going to be on Zoom today. He had the other hearing.
Ms. Beatty made it, apparently. So, and I have also, you have Mr. Edelman, Dr. Edelman here today.
I do, Your Honor.
Okay. Great. So I think what we're doing today is just a continuation about the questions, particularly on the surveys and where we go from here. You did drop off a sealed exhibit, right? Anything to say about this, or just?
Yes, Your Honor. That sealed exhibit goes with one of our discovery requests, that the exhibit that outlines what we're requesting has to be under seal. And so I had to hand deliver that to the court. A copy was hand delivered to the state. It is not up for discussion today.
Okay, great. Thank you. One other thing to just tie up is the order unsealing the state's motion for order prohibiting contact with prospective jurors. There was a discussion between both of you about redacting a particular sentence, maybe, last time. And so that we were going to take care of that.
I didn't. Ms. Taylor indicated that there was a sentence she thought we might want to consider redacting. I haven't heard back on that. And I know that she's been busy on other things since the 6th.
We want to just talk to each other for a second.
I understand the microphones in the courtroom are very sensitive. Perhaps we should do this after court today and go ahead and do the testimony of Dr. Edelman first. And I'd be happy to talk to the state afterwards.
Thanks. All right, so is that where we're starting now?
Yes, Your Honor.
Actually, Judge, I think we need to discuss some preliminary matters first.
Okay, go ahead.
As Your Honor indicated just a moment ago, this is a continuation of where we were on the 6th. And the issues on the 6th and the issues that we have here today is first, whether there was a violation of the non-dissemination order. And if so, where do we go forward from that point? And I think it was clear from our discussions on the 6th that the fact-specific questions did violate the order. I realize that the defense would like to proceed with those questions. That's perhaps an issue for today. But I just wanted to define what we're looking at today, because about 10:45 this morning, we got what was up on the screen there, a PowerPoint that apparently Mr. Edelman prepared. And as I understand, I don't think Ms. Taylor got it until sometime this morning herself. That's the information that I was given. And we have concerns because a large part of this PowerPoint deals with the issue of a change of venue itself, which is we are not prepared to address. It is not before the court at this time. It is premature. And I don't think that it should be part of this record as we proceed forward today. And so the state took a copy of preparing a printout of the PowerPoint. It doesn't take long to look through it. Perhaps the court might want to take a look at that before we proceed, at least with eliciting things from the PowerPoint. And I realize it's last minute, but the last time that we presented something to the court in advance, Ms. Taylor complained profusely. And I realized it was only 10:45 when we got this today. And so we just figured we would raise it with you now.
Okay, thank you, Mr. Thompson. Ms. Taylor?
Your Honor, I would disagree with counsel that the court made a determination that we violated the non-dissemination order. In my mind, that issue is very right for the court today, as is where do we go from here with the survey? Dr. Edelman has made himself available in court to explain the survey, the process of the survey, why it works, how long it's been used, how widely it's used, and what it doesn't do, and what it does do to present the court with some options to make a decision where we go from here. Whether the court decides we violated the non-dissemination order or not is up for discussion, and we're prepared to further argue that, but we think you need to hear the testimony first. As far as this PowerPoint, I had access to Dr. Edelman yesterday afternoon, and we worked on it late. I didn't have a final copy to give to the state until this morning. So they have it. We are not arguing venue now. We're talking about survey and how that relates to our change of venue motion. We know we're arguing the venue change later, but we have work that we still need to do. And that's where we are today, and would ask to present our PowerPoint and present our testimony with Dr. Edelman as we've prepared to do.
Okay. Taylor, so
Actually, Your Honor, Ms. Taylor still has a copy of the PowerPoint that made available to the court.
okay, so seems like this happens to me in this case that there's an argument about whether I should go ahead on something or provide some information that I don't see yet. So I feel like sometimes I'm making decisions that I'm in the blind here. So I'm gonna look this over. Any problem with that, Ms. Taylor?
Well, Judge, give me just 1 second. Your Honor, the purpose of the PowerPoint is to inform the court about the questions in the survey and the purpose of them. I can tell the court that showing up every time we want to have a hearing and have to fight to have the actual hearing is something I haven't experienced before either. There is nothing in that PowerPoint that the court can't hear today when making the decision about where do we go from here and did I violate the non-dissemination order. There's just nothing wrong with the process that we're doing here, and you're continually being asked to say there's something wrong with what we're doing. We're 10 after 4. I have a witness who's traveled here today, and we're ready to go.
All right, Your Honor, just to clarify, as we made clear the last time we reported, we are not saying Ms. Taylor herself violated the non-dissemination order. We're saying that the people who prepared the survey and disseminated the survey and called citizens of Latah County with those fact-specific loaded questions, violated the non-dissemination order, and they are agents of the defense. So I don't want this to become personal between Ms. Taylor and myself. We are not alleging Ms. Taylor has done anything wrong. We are dealing with reality that this survey was conducted on, as we understand it, 400, I'll say, innocent citizens of Latah County who were force-fed information that they may or may not have had about this case before they were called by the surveyor takers. And they are loaded questions. Some of the questions are factually wrong. They simply aren't true. That's what we're here about.
And that's what we're prepared to address, Your Honor. That's why we have a witness here. And if there's violation of the non-dissemination order, it's me. I'm the one that's bound by it. And the court just needs to hear about this process instead of hearing the conclusion that the state wants the court to reach.
Number one, I'm past that. I'm not going to violate you. I mean, this was a communication problem with Dr. Edelman not getting the order. One of the things I think that maybe needs to clear up, not for counsel, but maybe the public, is that one of the terms in that, and this is in the ethics, right, is what is the public record? Public record is not traditional media. It's not social media. It's not what anyone might say in public. Okay, that's the problem that we're kind of balancing here, because the public record is case that is available to the public in this case. I mean, I think we can all agree with that. No?
No.
You think the public record is whatever the media pumps out?
Your Honor, I think it's what's in the public, and what's in the public is derived from the affidavit that supported probable cause to arrest Bryan Kohberger. That's the first document that the court finds in the whole cases of interest on Idaho State Supreme Court's website. That document has a ton of information in it that relate to the questions in the survey for the case-specific questions. So that document became public record, and that was spread far and wide all over the place and reported and interpreted repeatedly. That's the public record. That's where the questions came from. There's no violation of the non-dissemination order if that's what we're going to talk about today, but I think the court should hear from our witness and understand a little bit more about this survey process.
I'm very interested in that. I told you last time that I'm interested in what he has to say about this, but
All right, as I mentioned, the questions in doing surveys is not uncommon. The issue is the type of questions. Normally you'll call someone and you'll say, hey, what do you know about this case? Those are general questions. Here they're asking specific questions. Did you know that DNA from Bryan Kohberger was found on a sheath? Did you know he was arrested at his parents' house? Very specific questions, giving information to people who might not have already had it. That's where the problem comes in. They're going to continue to argue that on the other side. We'll take a break. Keep it here on Court TV.
Tonight, on Closing Arguments, new insight into the defense's theory of the case in the Doomsday Prophet murder trial. We're breaking down today's opening statements as this trial gets underway. And a woman who pleaded guilty as a child to the infamous Slender Man stabbing is back in court seeking release. We'll unpack key moments from today's hearing with reaction from our think tank.
Closing Arguments with Vinny Politan, tonight at 8/7 Central, only on Court TV.
All right, folks, we're going to get you back to court in just a moment. But first, let me bring back in criminal defense attorney Darnell Crossland. Darnell, you heard some of the issues there, as I said. You have the general questions where you say, hey, what do you know about this case? And you take that information and you argue to the court, hey, too many people know too much about this case. That's why it needs to move. But here, they're asking very fact-specific questions. As a matter of fact, they're asking questions that aren't even true about the case because, again, they're taking this stuff from the media, and this guy is going to come into court, the guy who's doing the surveys, and say, it's the misinformation that's even more damaging, so he has to ask questions like that. I just want to get your thoughts on that specific issue.
Well, yeah. As it relates to that, the issue of the non-dissemination order, it's sort of tricky because obviously the prosecution here is saying we have no problem with Ms. Taylor, the defense attorney. We're not even saying she did this or violated this. We're saying agents of hers did that. And then you go to, okay, what is that? What is it? What happened? They're saying that this survey sort of indoctrinated the members of this county, the residents of this county, by telling them, things about the case that just simply aren't true. And also, whether one side believes it's true, another side believes it's not, that's still not the issue. The issue is that they're supposed to come into this case not knowing anything. And by way of this survey, it's telling them things about this case they should not have known. And then also what's important is that the Idaho Supreme Court governs what is a public record. And then so that intersected as well, where the defense is saying, Judge, let us have a chance to argue what the Idaho Supreme Court said and not just jump to shutting us down. And we're fighting just to make an argument. And that's, I think, what Ms. Taylor is frustrated about.
Yeah, I agree. And then the ultimate issue is, again, about 400 jurors were contacted. The question is, what do you do with the 400 jurors? You let them continue forward, or you just eliminate them and move forward without these surveys, all these issues in front of the court? All right, stand by, Darnell. I want to take folks back to court where the motions hearing continues in the Idaho student murders case.
Public record comes out of the case, right? That's public.
I'm saying in this case, that's exactly what happened, Judge. I don't want to argue the finer points of what's in the media, but I'm saying in this case, that's exactly what happened. That affidavit's there, and this court knows we have a ton of things that are filed under seal and more things that are not filed under seal. But that affidavit that began this case has been shared far and wide, and media stories have generated. When you understand how Dr. Edelman does his work to determine if a survey even needs to happen, you'll know where the information came from.
Okay, so I'm understanding, okay, the initial probable cause affidavit is part of the public record. And you're saying, well, that got spread, okay, by the media, as you would accept. And that's something that could be concerned. So what I think what Mr. Thompson is talking about, though, is information or questions that were not in the public record. And so what I'm nervous about this is I don't want to continue to spread things out that shouldn't be spread. And so I don't know what's in the slides, but if there's information in the slides that are not in the public record, that really have not been disseminated generally, then I don't really want to spread it. None of us want to spread it more than necessary.
Well, last week in court, that was right inside the courtroom. That all became part of the public record. The 9 questions were stated repeatedly in different formats by Mr. Thompson. That's part of the public record. We've been accused of violating the non-dissemination order. Dr. Edelman's reputation has been impugned by what was stated about him repeatedly. Those questions are fair game. But having this hearing and allowing our expert to talk about this process, that's not the problem. The problem with the media happened a long time ago, and it started with the sharing of the affidavit far and wide.
I understand that. I'm pulled in 2 different directions right now because I'm trying to protect your client at the same time. So if we keep talking about this, what is not true, okay? I guess we can just say, well, it's not true on some of these questions. Maybe that helps to reduce bias. But if we don't make that clear, then it could increase bias. I think. I don't know, tell me, maybe I'll hear this from the expert.
I'm going to say it like this. Mr. Kohberger is my client, and his rights are of the utmost importance to me. him being treated fair, his presumption of innocence, him having an impartial jury. Those are important things to me, as is his right to counsel. I am not standing up here saying, let me tell you about this survey. Let me finish this survey to hurt him. I'm saying there is pervasive media coverage in this case. It's prejudicial media coverage. We've conducted a survey in Latah County. That survey is going to show bias and that you shouldn't have a trial in this county. What I'm trying to do is say, do you want me to give you information about another place where maybe the bias isn't so great, where maybe Mr. Kohberger can have a fair trial? I'm his advocate. I want to help him. I believe in his innocence. I'm not going to stand in this courtroom and do anything wrong to him at all. I need you to hear the information so you can make a decision, to have the surveys, to have the information when we come back here for change of venue and make a decision on all of the information. Right now, if we come in and do our change of venue, we're going to say you can't have this jury in Latah County, but I can't tell you a better place that will protect him better. And that's what I want to do.
Any response, Mr. Thompson?
We aren't here to argue about venue today. We aren't here to argue about what this particular survey with the loaded questions, fact-loaded questions, may have produced in Latah County residents. As we mentioned last week, the structure of those questions assumes that every person that is called has heard all of the media in this case. And we know that that just simply isn't true. So for those citizens in this county who have not heard all of the rumors, who have not been following the media, who haven't inspected the court record, who are essentially ignorant of facts in this case, well, that's just been jaundiced by the questions that were asked. They have now been force-fed facts, some of which are not true, some of which would not be offered in court, and in fact, probably wouldn't legally be admissible in court, to somebody who may never have heard them before. That's the state's concern about the way this thing is put together.
All right, really strong arguments on both sides, actually. Tough position for the judge, and it sounds like we will get to hear from Dr. Edelman, the guy who crafted this survey, in a little while. So keep it here on Court TV, your front row seat to justice.
I'm Matt Johnson in Boise, Idaho for the Doomsday Prophet murder trial. You're watching Court TV, your front row seat to justice.
Welcome back to our special coverage. I'm Michael Ayala. A motions hearing is underway in the Idaho student murders case. The judge is hearing arguments on a state motion regarding a survey commissioned by the defense in support of their attempt to move the trial out of Latah County. Well, the defense argues they're not doing anything wrong. Let's get you back into court.
The arguments from the defense seem to be completely ignoring that point. That there are people out here who don't know all the things that they were being asked, and by asking the fact-specific questions, we were inoculating them with information that they didn't have before about this case that could affect their ability to sit as jurors. It's just simply irresponsible. It doesn't make sense.
Listen, this is one of the things that I was thinking about, is maybe we can inoculate by saying you can't rely on any of this information. It's not established by evidence. It's not been provided in court. But to just send a message out to be clear that these questions have nothing to do with guilt or innocence or even truth.
But that's not what was done, Judge.
I know. We have to fix this in some way.
Yes, sir.
That's what you said last time. And so I just want to help the public understand that this is not the trial.
Your Honor,
Yes.
at this rate, we may never get to trial. We know this isn't the trial. We brought Dr. Edelman to talk about the process, which will answer the state's concerns about this process. He hasn't even had a chance to tell you how this is constructed. He's the one that's the doctor of this kind of work. He's the one that's the professional. He's the one that knows how to do this. He's the one that spent his career understanding surveys and how to construct these. You need to hear from him. Going back and forth between what Bill thinks and what I think doesn't matter. What matters is you hearing from the expert to make a decision. He's here, he's ready to testify. We're 20 minutes into this hearing and he hasn't been allowed to take the stand yet. He came to inform the court about this process.
Well, there's no question I'm going to let him testify. I just wondered about what's in this. I haven't even looked at this, but it's you're comfortable having this come out into the public?
Yes, after last week's hearing, absolutely.
Okay, and you looked at it, Mr. Thompson?
We have concerns,
Is
Judge.
it alarming?
Well, part of what's in there is a part of the survey study being published now, if this comes to the public, without any comparison to anything else. And it's the product of these loaded questions. It takes us back to the fundamental issue of how this survey was conducted and the assumption that the people who were being called already knew all this stuff. And so it didn't hurt to specifically ask them, have you heard about such and such, the specific item? Well, if they hadn't heard about it before, they sure as heck have heard about it now. That's the core concern that led us to this in the first place. We don't dispute the defense doing a survey. I said that last week. Please do a survey, but don't go around screwing with the knowledge that prospective jurors have or may not have. That's our concern. And, Your Honor, when we parted ways last week, the court said, Ms. Taylor, talk with Mr. Edelman and see what the options are. Well, my understanding from the email I received the day before yesterday is the survey cannot be changed. That was from Ms. Taylor reporting what Dr. Edelman said. I interpret that as they don't want to change it. Anything can be done, but that's where we're left. I would have been happy to engage in discussion with defense about maybe some middle ground, but the line has been drawn black and white. I am concerned about the specific things that relate to venue, partial survey results that are in this PowerPoint. I believe it is premature for them to come out now. The rest of it is fine. Let's bring it out so that you have whatever information you want. You can give it the weight that you decide. I just didn't want to let this willy-nilly come into the public record in a half-baked fashion.
I have lots of concerns. We're not left with this because I have to make a decision about several things.
Yes, sir.
And so in order for me to have the most informed decision, I need the information. So they're just going to go ahead. All right?
Thank you.
And you can show your slides, and if something is concerning, we can talk about it along with it. All right. So, are you ready to call your witness? I think you are.
I am. I'm ready to call Dr. Bryan Edelman.
All right, we're going to take a break here. When we come back, Dr. Edelman will be taking the stand to explain his surveys, why they're crafted this way, to figure out if there's bias amongst potential jurors. So keep it here on Court TV, your front row seat to justice.
Tonight, on closing arguments, new insight into the defense's theory of the case in the Doomsday Prophet murder trial. We're breaking down today's opening statements as this trial gets underway. And a woman who pleaded guilty as a child to the infamous Slender Man stabbing is back in court seeking release. We'll unpack key moments from today's hearing with reaction from our think tank.
Closing arguments with Vinnie Politan tonight at 8/7 Central, only on Court TV.
Welcome back to Court TV Live. I'm Michael Ayala. We continue now with our coverage of the Idaho students' murder trial, a special hearing going on regarding some surveys being used by the defense. They have called now Dr. Bryan Edelman to the stand. He is the scientist or the trial consultant that really constructed these surveys in question, and he's a change of venue expert. So let's get into the courtroom now to listen to his testimony.
I've been doing this for about 15 years, I'd say, as an expert witness on this area.
On change of venue
On change of
specifically? Okay. And to do with surveys, just to be clear?
Yes. From some of its surveys, other times it's post-conviction, once again. I've done it federal cases, state cases, multiple states, including Idaho. But the way I learned was from Dr. Ed Bronson, who was kind of the pioneer in the field. He worked on cases like the Oklahoma City bombing case and a host of other prominent ones, the Boston Marathon, a bunch of them. So he was kind of my mentor in this area. And there's a 3-stage process. So the first phase is collecting the media coverage. Because really the question is initially, is there extensive coverage and is there prejudicial coverage? So I collect the coverage and assess the nature of that coverage. Does it include inflammatory language? Does it include inadmissible or misinformation? Now, just because it's not true does not mean people don't see it, and it does not mean that they don't develop opinions based on that information. So it's very important. In fact, some of that stuff is the most prejudicial stuff that there can possibly be. For example, if there is a prior conviction and then the conviction's thrown out, well, that's pretty prejudicial for the new trial. Not admissible, but very prejudicial. So I'm looking for information like that. I'm looking for references to prior records. Maybe they're victim impact statements where people, the victims' families may be suggesting what the outcome should be. That could be prejudicial. How did the community respond? Are there candlelight vigils? Are there, GoFundMe efforts going on? The status of the victim, is it focusing on that? So there's a gambit of things that we look at. Sometimes there's political elements that are important in high-profile cases because it might be that a politician's involved. So it just depends on the case. So the first thing is assessing the nature of the publicity. Now, if there's not a lot of extensive pretrial publicity and it's not prejudicial, it stops there. And that's happened where there's coverage, but it's very superficial. It's very neutral. There's not a lot of detail. There's nothing particularly impactful. Maybe it's focused primarily on just the victim or something like that. However, there are other cases where there is extensive pretrial publicity, and then I would recommend phase 2, which is a community attitude survey. Because just because there's prejudicial coverage does not mean it had an impact on the jury pool. And that is the question that matters most. What impact has the prejudicial media coverage had on the jury pool? I don't really care if it's correct information, it came from social media, it came from the news. It had an impact on the jury pool. That's what matters because they develop opinions and attitudes. And it doesn't make a difference if that fact's true or false. They still develop an opinion and an attitude about the defendant, about the evidence and perceptions of guilt. All of that is what I'm looking at. So I want to see if the media coverage has had an impact. And that's why we do a community attitude survey. And then depending on the results of the survey, there's not enough evidence there to suggest that anything is required. It could be remedial measures such as individual sequestered voir dire. Maybe that's appropriate in some cases, all the way to the extreme case where it might be a change of venue.
I want to understand a little bit about the source of media you review to do your work. Can you tell me what you take a look at?
I always take a conservative.
Your Honor, I'm sorry, I need to object. This PowerPoint is being played for everybody with no foundation. It's not an exhibit. I think that's improper. I mean, I'm trying to listen to Dr. Edelman's testimony, and I keep seeing slides changing in front of me over here, and I don't think that's appropriate.
Well, you've seen the slides.
I have.
You looked at
But
it.
everybody else here hasn't.
What I'm seeing here, though, is just an explanation of how he goes about in surveys.
Understand that. That's what his testimony is. But we're getting this visual aid that there's no foundation for, Judge.
Well,
It just seems.
well, hold on. I'm viewing him as an expert.
Yes, sir.
He's explaining what he does. So I'm going to.
No problem with that. The PowerPoint's a problem. I don't have any problem with his testimony.
All right.
I'm sorry. I
Yeah.
frankly, I've never seen something like this occur.
That objection. I mean, this is not necessarily factual. It's just an example of how he got to where he got.
That's his testimony, but the PowerPoint is different, Judge. I don't know why we're seeing the PowerPoint when we have his testimony.
You want to respond to that?
I do, Judge. This is a courtroom demonstrative aid that helps to track the testimony of Dr. Edelman. I can hand him my computer and let him advance the screens if that makes a big difference in it. This just helps explain his testimony.
Judge, we don't have a jury here. Let's just proceed.
Thank you. Proceed. Go ahead.
Dr. Edelman, we were talking about where you get your information.
We were talking about the what?
Where you get your information. What media do you look at? I think that's where it works.
Yes. So I take a conservative approach to how I do it. I look at newspapers in the local coverage right now. So I'm interested in papers that have primary circulation in the venue. Case like this has been reported in many other newspapers, but I wouldn't, for example, look at a newspaper published in Dallas because I don't know if somebody in Latah County would be looking at a paper in Dallas. So I look at the local coverage. I try to look at like local television coverage to see what the community is likely exposed to.
While we're here, I want to ask you some questions about the non-dissemination order.
Okay.
That's been a hot topic, and you've heard some of it again today. Are you aware that there's a non-dissemination order in this case?
Yes.
How did you become aware of it?
Well, the first time I became aware of it was when I was reading the newspaper coverage, because that was one of the topics of media coverage, was discussing the non-dissemination order and media's efforts to have it changed. So I was able to read it and follow it in that media coverage. So that's the first time I saw it.
And in January, did you receive an email from my office with the non-dissemination order?
I believe I did.
And you looked at a hard copy again recently?
Yes.
All right. Does that non-dissemination order change how you did your work?
I'm sorry, can you even know?
Does the existence of the non-dissemination order change how you did your work?
No, it did not.
Have you worked in cases where there's a non-dissemination order at other times?
Many times.
Was the sole source of the information that you used contained in the media?
Was it came from the media? Sorry. Yes. Everything I used was widely disseminated through the media. Widely disseminated.
Did you find out where the media got the information?
Yes.
Good afternoon, folks. My name is Bill Thompson. I'm the Latah County prosecutor. And it's sad to be here, but happy to be here at the same time.
You turn it up.
I can't hear.
Kohberger,
Well, I'm going to do my best to turn this up.
Yeah, you don't have to.
If I put the microphone up, is that better?
So yeah, but you don't have to type things that are recorded here.
and let me preface, there is a pending case now in court, and I and my office and the investigators have to live with the restrictions that our Supreme Court places on pretrial publicity. That said, I promise you we will share with you through the court process or otherwise whatever we are allowed to. I just appreciate your patience on that. The factual basis for the charges are summarized in what's called a probable cause affidavit that is on file with the court. According to the rules of the Idaho Supreme Court, that is sealed until Mr. Kohberger is physically back in Latah County and has been served with the Idaho arrest warrant. At that time, we expect that that affidavit will be available to you so you can share the true facts with all of your readers and your watchers and your listeners and all of the people who are interested in really.
All right, that's going to wrap up our coverage for tonight. Thanks to my guest, Darnell Crossland, for being with us. I'm Michael Ayala. It's been a pleasure being with you.